and welcome to Arbitral Insights, a podcast series brought to you by our international arbitration practice lawyers here at Reed Smith. I'm Peter Roscher, Global Head of Reed Smith's International Arbitration Practice. I hope you enjoy the industry commentary, insights and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started.
Welcome to the latest episode of our Arbitral Insights podcast series. This is the fifth in a series of podcasts which I'm doing with the FDL, where we explore arbitration across various jurisdictions in South and Southeast Asia. We have so far covered Bangladesh, Cambodia, Indonesia, and Thailand. For this episode, it is my privilege to host Nishan Chowdhury, who will share insights from Myanmar. Nishan is the Managing Director of the FDL's office in Myanmar. He is also the FDL's Head of Regional Dispute Resolution. Good afternoon, Nishan. Thank you for joining me on this podcast today. I'm really looking forward to our discussion.
Hi, Joyce. It is a pleasure to be here, and thank you for inviting me. I too look forward to our discussion today.
Nishan, I understand that unlike most countries in the region, arbitration is not a new concept to Myanmar. In fact, Myanmar actually had an arbitration legal framework before the New York Convention was signed in 1958. Could you tell us a bit about how arbitration has evolved over time in Myanmar and what the current legal framework for arbitration looks like?
That's a very interesting question. Myanmar has a long history with arbitration. Arbitration was a familiar and often preferred method in ancient Myanmar legal tradition. And we even have historical digests of famous arbitrators like Konto Monchaba, which evidence the fact that there has been a legacy of arbitration as a dispute resolution mechanism in Myanmar. Our first arbitration law was Arbitration Act of 1944, which came into force on 1st of March 1946. Myanmar then acceded to the New York Convention in 2013, which was a major alignment with international arbitration standards and replaced the 1946 arbitral law with the current arbitration law of 2016. The current arbitration law is largely based on the UNCITRAL model. More recently, the Union Supreme Court issued the arbitral procedure in 2018, which further outlines the procedural details for arbitration, such as appointment of a sole arbitrator and a presiding arbitrator for domestic and international arbitrations. It also includes procedures regarding court jurisdiction and recognition and enforcement processes and appeals. It prescribes for qualification of arbitrators. Importantly, the procedure defines the term contrary to national interest, which it defines as anything which impacts and damages the state-owned natural environment, such as land, water, air, violates the interests of all citizens or harms nation's cultural heritage. Some of the key differences between these periods of evaluation of arbitration are, which can be broadly divided into three categories. First being before 1944, where arbitration in Myanmar was informal, based on traditional and customary practices. Disputes were typically resolved by respected community elders or local leaders, with decisions guided by social norms rather than formal legal rules. These methods were widely accepted but lacked enforceability through a formal legal mechanism. After 1944, the process became legally binding for the first time. However, it was purely for domestic arbitration. Neither did it provide for enforcement of foreign award. It gave courts the authority to intervene at an early stage to decide the jurisdiction. So there was no principle of competence at that point in time. Importantly, the award could be without reasons unless both parties agreed that the award has to be an speaking award. Following the arbitration law of 2016, which brought in line with the international standards, particularly the UNCITRAL model law, the new law allows for both domestic and international arbitration. strengthens the enforcement of foreign arbitral award procedure, and limits court interferences. This marked a major step towards making Myanmar a more arbitration-friendly jurisdiction, especially in cross-border and commercial disputes.
That was such a fascinating explanation of how arbitration has evolved in Myanmar over the years. In light of this long history, is arbitration in fact commonly used to resolve disputes in Myanmar now?
Although Myanmar now has a modern UNCITRAL-aligned legal framework and governing institutional support, I would be candid in saying arbitration is still not mainstream. Local businesses and practitioners still lean heavily towards litigation, largely due to limited awareness of arbitration processes and a lack of practical experience. Foreign investors, however, often prefer arbitration, typically under ICC or SIC rules, and usually seated outside Myanmar. This is due to concerns regarding efficacy, neutrality, and predictability in the domestic courts.
That's interesting. You mentioned in particular that foreign investors tend to prefer arbitration seated outside Myanmar. This is definitely a trend which we are seeing in the region. And in fact, based on my previous discussions with your colleagues, Singapore appears to be a popular choice of seat for countries in the region. Is this consistent with what you're seeing in Myanmar?
Oh, yes, certainly. Singapore is by far the most popular foreign seat for Myanmar related contracts, followed by established seats like London or Hong Kong. The main reasons would be perceived neutrality, efficiency, experienced arbitrators, importantly, the proximity, and the predictable enforcement drive, the choice for the contracting parties to opt for Singapore as the preferred seat of arbitration.
Well, that's good news to me. I mean, Singapore's popularity as a seat is great for someone based in Singapore like me. In all seriousness, though, there may well be situations where the balance of negotiating power means that the foreign party has to seriously consider agreeing to Myanmar as a seat for any potential arbitrations. Do you have any advice for parties who find themselves in this situation?
So, it is worth noting that under 1944 Arbitration Act, many government departments contracted with foreign parties mentioned Myanmar arbitration. That's also because there was no foreign arbitration procedures under that law. But since the shift towards the market economy in 1989, private contracts, especially with foreign investors, have tended to refer to foreign arbitration instead. If choosing Myanmar as an arbitral seat, parties should be mindful that Myanmar's arbitration framework is still in the very early stages of development, and institutional capacity remains limited. The pool of experienced arbitrators and practitioners is very small, and parties often need to appoint lawyers or experts based in Myanmar to act as both merits and procedural counsel. For foreign companies, these limitations, particularly in expertise, institutional experience, and international competitiveness, mean that well-established international arbitration centers, such as those in Singapore or London, may be more suitable for complex, high-value cross-border disputes. There are, however, ways to deal with these limitations, and I recommend that parties obtain advice from local councils at the contracting stage to ensure that any concerns with agreeing to a Myanmar seat are properly mitigated, for example, by a well-drafted arbitration clause that specifies the procedural rules and clearly outlines the methods of appointing arbitrators, including the option to appoint foreign arbitrators and experts, clauses about language, and limiting court intervention for interlocutory processes.
That all makes complete sense, and thank you so much for these tips. Nishan, I'm sure you'll agree that although most arbitrations relating to Myanmar-linked contracts are seated outside Myanmar, the courts in Myanmar still have an essential role in ensuring that parties are able to enforce foreign arbitral awards against assets located in Myanmar. Would you describe the Myanmar courts as being generally pro-arbitration?
Yes, Myanmar courts have shown growing support for arbitration, making a positive shift in their approach to arbitration-related matters. A key example is a landmark 2021 decision by the Western Yangon District Court, which recognized and enforced a foreign arbitral award issued by SIAC. This was the first reported enforcement of a foreign arbitral award by a Myanmar court since the arbitration law of 2016 came into effect. In addition to arbitration, the courts have also embraced other forms of ADRs. In 2019, the Supreme Court, with support of JICA, which is Japan International Cooperation Agency, launched a court-led mediation program, which was expanded to all courts nationwide by 2022. According to 2023 annual report, roughly 5,000 cases were referred to mediation, of which almost 50% were successfully settled. The remaining 50% cases were not mediated, primarily due to the absence of one or the other parties. Overall, 789 cases resulted in positive outcome through this program. Overall, these developments reflect the Myanmar court's broader effort to reduce the caseload through combination of supporting arbitration and promoting court-led mediations.
It's certainly positive to hear from you that the Myanmar courts are increasingly receptive to arbitration. This will no doubt be the result of concerted efforts in the region to promote arbitration as a mode of dispute resolution, which complements rather than threatens litigation. What about foreign arbitrations? Can the Myanmar courts issue measures such as injunctions or asset preservation orders in support of foreign-seated arbitrations?
Yes, it is expressly provided under Section 11 of the Arbitration Law of 2016. Myanmar court have the power to grant interim measures, including injunctions and other orders to preserve assets in support of arbitration proceeding, even where the seat of arbitration is outside Myanmar. These interim measures can be sought before the arbitration commences or during the proceeding, and they apply to both domestic and foreign-seated arbitrations.
What about interim orders and awards issued by the tribunals in these foreign-seated arbitrations? Can they be recognized and enforced in Myanmar under the New York Convention?
In theory, yes. However, there are no reported cases dealing with this point. So I would recommend that parties look to a Myanmar court for interim relief in the first instance.
Understood. That's really helpful to know and will no doubt affect parties' litigation strategy. Let's move on now to discuss the important topic of the recognition and enforcement of final awards in Myanmar. As a signatory to the New York Convention, there are, as you said, in theory, only limited grounds by which a party can resist recognition and enforcement in Myanmar. But is this what you see in practice?
To be honest, there is very little publicly available information on cases regarding the recognition and enforcement of awards in Myanmar. Only Supreme Court cases are available on Supreme Court's website, and there is no equivalent to LexisNexis, Westlaw, or similar journals in Myanmar. Section 46 of Arbitration Law states that foreign arbitral awards are recognized and enforceable in Myanmar, subject to grounds of refusal of recognition and enforcement as set out in Section 46 itself, which largely mirrors the grounds under the New York Convention. For the purpose of this discussion, probably the most interesting ground is the public policy ground. In other words, where the award conflicts with Myanmar's national interest. While the term national interest employed in the arbitral law is defined to an extent in the 2018 procedure, the terms are so broad that it has many dimensions of interpretation. The 2018 procedure states that any impact that damages the state-owned natural environment, such as land, water, and air, or violates the interest of all citizens or harms the nation's culture and heritage, thereby granting the court significant discretion in deciding whether to refuse the enforcement of award or not. That said, there are examples of Myanmar courts using the discretion wisely. A notable example of this ground being used to resist recognition and enforcement is the AVR Offshore Company Limited versus Myanmar Offshore Company Limited case of 2021, where the resisting party raised the objection, but the court enforced the SIAC award, affirming that if the legal requirements are met, enforcement will be granted. Significantly, the court refused to misuse the national interest ground to block a valid foreign award, showing a pro-enforcement approach when the law is followed.
That's great to hear. It's great to hear that the Myanmar courts are being very wise in their application of the discretion and complying with international standards in doing so. Looking at the enforcement process itself, Nishan, how would a party look to recognize and enforce a foreign arbitral award in Myanmar?
Actually, the process is quite structured, and it's set out under the arbitration law of 2016 in line with the New York Convention. First, the party seeking enforcement needs to file an application with the Myanmar court in the district which has jurisdiction over the assets. The Limitation Act states that if a foreign award is registered in the relevant country, it remains valid for a period of up to 6 years from the date of the award. If it is not registered, it's valid for 3 years from the date of the award. Thus, we need to be mindful of the limitation. Now, while filing the application, we must include the original or the certified copy of the arbitral award, the original or the certified copy of the arbitration agreement, and if either of those documents are not in English, a certified English translation. And importantly, all of these documents have to go through proper legalization process before filing. Once the application is in, the court will presume that the award is valid unless the opposing party comes forward and proves one of the recognized grounds for refusal. If court recognizes the award, it treats just like a Myanmar judgment, which means you can then move into the execution process to actually enforce it like a decree of a court.
That sounds fairly straightforward and consistent with global practice. How long does this whole process tend to take?
Recognition and enforcement typically take 6 to 8 months. The authority to recognize and enforce foreign arbitral award is vested in the district level courts. Accordingly, a party may appeal a district court's decision to a relevant regional or state level high courts and subsequently to the Union Supreme Court. Each appeal process may typically take up to 6 months. Execution against the assets depends on the relief granted. So, specific performance would take roughly 1 to 2 years. Monetary relief depends on the payment or property attached and execution processes, which can take 8 months to 3 years or more.
I see. With the current political and economic situation in Myanmar, are you seeing additional delays in foreign parties being able to recognize and enforce foreign awards in Myanmar?
In practical terms, the civil war has not have much impact in main commercial centers. Most courts in Myanmar are functioning normally. The disruptions are mainly in certain parts of the east and west where there are active conflicts ongoing. But in major cities like Naypyidaw, Yangon, and Mandalay, court operations are continuing as usual. So recognition and enforcement of proceedings can still go ahead without major delays. Execution is, however, a different story. Due to strict foreign exchange control imposed by Central Bank of Myanmar, repatriation of fund abroad is extremely challenging, even after a successful enforcement. Pursuant to a notification of 2022 issued by Central Bank, all foreign currency payments out of Myanmar are required to be approved by a special administrative body set up for the purpose, which is called Foreign Exchange Supervisory Committee. Now, FESC approval usually takes between 2 to 3 months, but can be extended beyond 6 months in cases involving huge amount of transactions or depending on the nature of transaction. not specific to an enforcement situation, but we have seen many investors with large cash exposures in Myanmar invested in the assets onshore to overcome foreign exchange challenges and be able to dispose it off on the upside after the political situation improves.
That's another great tip, Nishan. Bearing in mind what you've just said, what advice would you give to foreign investors and businesses to improve their chances of successfully enforcing an award in Myanmar?
I always tell clients to think about enforcement from day one, not just after they have won the award. At the contracting stage, make sure you have a clear enforceable arbitration clause. Name the institution, the rules, the seat, the governing law, and the language. And if you know there are assets in Myanmar, think about building in security arrangements like guarantees or charges that could help later. Before you even start proceeding, what I call the pre-proceeding stage, you want to map out the other side's assets in Myanmar. Engage local councils early to flag any enforcement issues under the arbitration law, especially the refusal grounds under Section 46. During the arbitration itself, procedural discipline is key. That means giving proper notice, following the agreed rules, and making sure both sides have fair chances to present their case. Keep your evidence well recognized so that the records will be critical for enforcement in the court. Then, once you have got the award, move fast. Get the award, the arbitration agreement, and any translation legalized straight away. File your recognition application promptly. And if you think the asset might disappear, do not hesitate to apply for interim measures. Our courts can grant injunctions or asset preservation orders under Section 11, even for foreign-seated arbitrations.
That is all very sensible advice. Thank you, Nishan. As you wrap up, I would be very interested for your observations on key emerging trends for arbitration in Myanmar. What should we look out for in the next few years?
So the biggest factor on horizon is political in Myanmar presently. Myanmar is scheduled to hold a general election at the end of this year. That will almost certainly bring a new government, and in my view, changes in government and broader policy priorities will take precedence over developments in arbitration in short term. So I wouldn't expect major shifts in arbitration landscape in the next year. Any real changes are more likely to come after the elections in the next few years. That said, depending on the approach of the newly elected government, we could see reforms within the next 2 to 3 years, possibly aimed at improving enforcement procedure and further aligning with international best practices. But nothing concrete is on the immediate legislative agenda, to my mind.
This is completely understandable. There needs to be stability on multiple fronts before arbitration reform can properly be on the agenda. Final question for you today, Nishan. What is the one key point which you want our listeners to take away from this podcast?
If I had to boil it down to one point, it's this. Myanmar now has a modern arbitration framework that's aligned with UNCITRAL model law and backed by New York Convention. But successful outcome, especially for foreign investors, depends on preparation. That means drafting clear arbitration clauses, complying with procedure to the letter, and working with the local councils from the very beginning. If you do that, the system here can work for you.
Awesome. Nishan, thank you so much for joining me today. It has been such an interesting discussion, and I'm already looking forward to a follow-up podcast in a year or so.
Certainly, Joyce, it was a pleasure discussing with you. I look forward to our next discussion.
Arbitral Insights is a Reed Smith production. Our producers are Ali McCardle and Shannon Ryan. For more information about Reed Smith's global international arbitration practice, email arbitralinsights@reedsmith.com. To learn about the Reed Smith Arbitration Pricing Calculator, a first-of-its-kind mobile app that forecasts the cost of arbitration around the world, search Arbitration Pricing Calculator on reedsmith.com or download for free through the Apple and Google Play app stores. You can find our podcast on podcast streaming platforms reedsmith.com, and our social media accounts at ReedSmith LLP. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to ReedSmith LLP or its individual lawyers. All rights reserved.